Good morning. Oh, good afternoon. Actually, this is Diane Cohen. I'm joined by James and Elizabeth from the Rossi Law Firm. My apologies. Yeah, my apologies. I'm a little bit sick, and so I'm a little off today. But James and Elizabeth, we've been visiting. You guys are great. How are your holidays going?
Well, I'll
Good,
let you go first, Lizzie.
good. Just trying to get all the shopping done and figure out the menus for different holiday events. It's exciting but stressful. I'm sure everybody has the same kind of thing going on, but we've already started all the festivities. It's been going on all month, so it's been great.
Nice. And James?
Well, my wife and I are doing something different this year where I got to go pick my presents. She picked hers. I'm wrapping the ones she picked. She's wrapping the ones I picked. And I can't tell you, I'm so excited to see what I'm getting. I just
That
wonder
has
if I'll really get it.
Yeah, that has been my husband and my tradition for many years, where we have a budget. I buy my own presents, he buys his own presents, and then on Christmas morning, I open his and vice versa. And then he can tell me why he bought those gifts. So I love that. I think it's
Yeah, I think
fantastic.
we'll see how it works, but I think it might be the new thing. And
Yeah,
she's the only one I ever really have to worry about because she takes care of everybody else.
it's good to have a wife like that, a spouse for
Yeah,
sure, right?
yeah.
Okay, so let me ask everybody else, do you guys have a tradition like that in your family? Are you finished shopping or you still have to shop? Let's go with that. Are you finished or do you still have more shopping? You can put that into the question box. And oh, Corey says that still has to do some shopping. So
Oh,
yeah, so I think a lot of us are in that same boat. Other people are saying, oh, they're typing it all in. Let's see what else they're saying here. Oh, they have lots of shopping done. And Kevin,
That's good. That's good.
all of his is done. Renee says she's got more shopping to do. So, yep, I think you're either really organized and you're done, or you're like the rest of us and still have to do that. Okay, so I'm going to give you a little bit of housekeeping and then we'll get started with our webinar. So today's 12 CEUs Christmas will be worth 1 CEU credit. You should receive your certificate within 1 day. However, we are finding people's firewalls are not returning them in 1 day. So please give it a day and a half before reaching out to your IT department first, and then to me if you still don't get it. Secondly, if you have any questions for James or Elizabeth, we'd like you to put them into the question box, and I'll be happy to read those to them at the end of the presentation. And then if you're just sitting there and you're following along and you love those handouts, please make sure that you download them. James also included an article for you to read. So make sure that you download those from the control console. It says handouts and you can download those now. And then lastly, we'll have an encore presentation of this. And I hope that you two have a fabulous webinar. I will talk to you guys at the end.
Sounds good.
nice.
And just for one more housekeeping, anybody who needs one of these laminated defenses reference sheet, put a note in there for Diane and she'll let me know and we'll mail it to you so you'll get one. As always, I like to get them to you because I think they're such a great tool. But for today, we're going to talk about case law, legal authorities. We're going to talk about DORs, pretrial conference statements, and we're just going to give you a brief overview. We're going to start with the hierarchy of the courts, and then we're going to go into the types of legal authorities there are and which ones you have to actually follow, which ones you don't, and then we'll touch on the rest. So for the first thing we're going to do is just give you an overview. Next slide, Lizzie. And by the way, for those of you that don't know, Lizzie is the Senior VP at Rossi Law Group, and I think she's absolutely amazing. I think the world of her, both as an attorney, as in a person, and I'm very happy to have you here, Liz.
Well, it's mirrored back at you. So I'm happy to be here, and James is somebody that I consider to be a mentor and somebody who really knows what he's doing in this field and in life. So
Well,
I'm
I got to say, I'm definitely your mentor.
yes,
That's for sure.
100%.
So we're going to cover the courts first. This is the hierarchy in the United States federal courts. It starts at the district court, which is the trial court level. In workers' comp, there's administrative courts. And then it goes up to the Court of Appeals, which is, we're in the Ninth Circuit. There's each state has a different circuit that they're part of. We have, I want to say, like 5 states in the Ninth Circuit. And then it goes up to the United States Supreme Court, which is the law, the court of the land, the top of everything, the top of the states, you name it. It is the Supreme Court, the Supreme Court.
And then we have the state court system, which is pretty similar in terms of the structure. You have the superior courts, which are those trial level courts where you would have, let's say, a civil claim or a criminal case would take place in a superior court. And then you have the Court of Appeals, that's the next level up. And then, of course, the state Supreme Court, which is the highest court that you can get to in the state of California, or any state for that matter.
Here's a diagram of what it looks like. So you've got the US Supreme Court at the top on the left. You start at the trial court, which is the district court for the federal, to the Circuit Court of Appeals, up to the US Supreme Court. And then for state courts, you've got the state trial court, or in our case, the administrative court, the WCAB. Then you've got the appellate courts, and then you've got the state Supreme Court.
Now, the mother of all authority in California would be the California Constitution. That's the underlying source of every law that you can look at in California. It gives the power to the state to create the workers' compensation system, which is what we all deal with on a daily basis. Hopefully liking it. Some days maybe not so much, but typically yes. And the Constitution is over every other sort of rule, whether it's a statute or a regulation, things like that. Those underlying or lower level rules, so to speak, all have to be consistent with the California Constitution. And if they're not, you can see different courts that will, or different parties, I should say, that will appeal certain types of statutes or regs to try to have them declared unconstitutional, and so that they are no longer followed.
Yeah, there's one that I've wanted to, I don't know if I'll ever have the opportunity, I've wanted it, is there's a code section that the state death without dependents unit gets $250K. You know what I'm talking about? Yeah. If there's no dependents. And I've always felt like that is unconstitutional because, and one of these times it's going to get tried by somebody, if it's not me, but I feel like it's unconstitutional because if someone had one dependent and it came to 20,000, that's all it would cost. Yet here you got someone, there's no dependents, and you're going to require $250,000, and it just doesn't seem like it's equal protection.
Not to mention,
very interesting.
The whole point of that is, if somebody dies due to a work-related injury, you're supposed to be compensating the family or whoever is dependent on that person to help pay their bills and have a decent life. And if there is no dependent, why should the state get this huge amount of money? Is it because now the state doesn't get to tax them on their earnings? I don't know, I guess.
Yeah, I don't either. But one of these times it's going to get challenged, and it'll be interesting to see how it turns. So statutory authority, that actually is in line with what I'm saying, is these statutes are passed by the California legislature. The main one that we follow is the labor code. And the only way you can invalidate a statute is passed by the legislature is if it's found to be unconstitutional. That doesn't mean they can't be amended or repealed, because they are all the time. Oftentimes you get your new book with all your codes, regulations, etc., the labor code book each year, and there's all kinds of amendments and repeals. So you've got to always look at it. And that's why as a lawyer, we always have to update our knowledge of the law to make sure that that law is still the law. In fact, I can remember a time where I was reading a book that also had an online reference, and the book was basically saying what I didn't want it to say, and I thought, my goodness, this is a big problem. And then I found out that it actually was amended. The book was a year old. They had amended it and changed it to exactly what I needed it to be. So you got to always know whether something's been amended because it happens so often.
Yeah, in this day and age, I think it's almost always best to check online, even if you're one of those people that likes to hold the book and read it physically. Checking online is really important, particularly
Yeah,
for us.
it's pretty crazy. In our main office, we've got bookshelves full of law books, just full of them. And when I first started in the legal career, it was we had a library. The firm I was at, we had a library, and that's where you did all your research. And you didn't have access to the world. You had access to whatever books you bought. And so now we have an office that has, I don't know how many, probably 2,000 or 3,000 books. And we don't use a single, well, we use almost none of them. We use about 2% of them. And the rest are really there for looks.
Yeah, I was going to say,
It's
I
all
remember
online.
before I was an attorney and was working as a law clerk, one of the things I did was put in the new pages when the workers' comp practice guide was updated. We'd get the new pages and I'd have to go in and replace them so they were updated. But yeah, I bet people haven't really cracked that open in a while.
That's funny.
But yeah, underneath
All right,
the
so
labor code, we've also got the California Code of Regulations, which is something that's developed a little bit differently. This isn't passed into law by the legislature. This is every state agency has the ability to come up with their proposed regulations, which then are submitted to the Office of Administrative Law. There's typically a public hearing and notice of opportunity to chime in on thoughts about these proposed regulations. And then as long as they are eventually approved by the Office of Administrative Law, they are then filed with the Secretary of State. And this is one of those sections that you're going to want to pay attention to the updates because they actually update this weekly. And it's electronically updated. They do publish their Code of Regulations every year in hard copy, but those automatic updates are going to be seen online. And the California Code of Regulations covers a heck of a lot more than just workers' comp. But if you are looking for workers' comp regs, you're going to be looking at Title VIII, Industrial Relations. That's where everything that you're going to want to look at is going to be found. So don't be
yeah,
led
it's
astray.
pretty much all we look at these days. Doing workers' comp, you're not going to really go outside to Title VIII. And even Title VIII, you're only going to look at a small portion of that.
Right. And these are the lower level rules, I guess you could say, that if the labor code contradicts it, the labor code trumps the regs.
Yep. All right, so that's that. And now we're going to talk about the work comp system specifically. Basically, it starts with the district office. That's the office that you guys are all very familiar with. Which WCAB office are we in? LA, Marina, Anaheim, Santa Ana, where they've got all the judges and they do the hearings and the trials. And that's where our day-to-day is spent 99% of the time. Then we go to the appeals board, and that's when there are appeals such as a petition for recon or removal. And that's the second level. And then the next level is a writ to the California Appellate Court, which doesn't happen a lot. And unfortunately, it's not an automatic right to be heard. And then lastly is a writ to the California Supreme Court. And that's the system. And you can see that picture right there is a picture of it looks like Judge Barbosa's courtroom. Is that in Pomona?
She used to be in Los Angeles. I think that's probably from Los Angeles.
Well, she was in Los Angeles, but I thought I read Pomona now, but maybe that's Los Angeles. But anyways, let's go to the next slide.
So the WCAB, the decisions of the local judges. Now these are, again, those judges like Judge Barbosa or any other judge at one of the local district offices. These decisions are issued after a trial. Now this can be a trial on one issue, it can be a trial on all issues, and then you'll get a findings and award or a finding and take nothing, which is something we always like to see on the defense side of things. Now these decisions that a WCJ, again, just the trial level judge issue, are not binding precedent. What that means is you can't get a favorable finding from Judge Barbosa and then walk around waving it around to everybody and anyone and think that that's going to get you much. They basically just provide guidance as to what a particular judge thinks about a specific issue. Now, does that mean that they're not useful in some respect? No, they're of course useful, if for no other reason than you know how a judge thinks, you know how closely tied to procedure they are versus somebody who's willing to maybe throw out some procedure and just look at the big picture. And so that can help on either applicant side or the defense side to decide whether or not to keep an assigned trial judge. Because as you may or may not know, once you get a trial judge assigned, you do have the opportunity to strike that judge. Now, that doesn't mean you get to pick your judge, you just get to strike one. So sometimes taking the devil you know may be better than rolling the dice and getting a different judge.
Yeah, that's a good point with respect to being able to strike them. If you know how they're thinking, then you're going to go, well, I know this judge ruled a way I don't like. I'm striking that judge. Yeah, that's a good thought.
And that's, I've had actually pretty recently this year, different lien claimants sending me these decisions from judges, even opposing counsels for 5710 fee issues, sending me decisions from local judges that are, first of all, not the judge we're set before, or second of all, not even a judge at the same venue we're set at, but they do give you some idea of how at least one judge decided an issue. So if you have the same issue before a different judge, you know, it at least gives you some kind of an idea how somebody did decide. But they are not binding. You are not allowed to cite these. If you were to prepare a brief on an issue, you're not supposed to be citing these WCJ decisions.
Yeah, I, with these opinions, it's hard to get your hands on them too, because typically the only people that are going to see it are the parties to the case. Every now and then you get them. I remember I had a case where there was an issue of interpretation of the labor code, and this applicant attorney was being really, really aggressive. I was confused at her interpretation of the law. It just was completely wrong, in my opinion, on its face. And I kept trying to tell her, and she just wouldn't buy anything I was saying, and pushed us to go to trial. And I ended up getting a copy of a decision that this same judge, who was our trial judge, had issued only like 2 weeks earlier. And it was on the same issue, and he ruled in my favor. And so I was able to use that because this is the same judge. This is what he's going to do. And it's clearly right. And then in other instances, when I get a decision from the local work comp judge, I can use that to develop arguments, because you know, a good decision can have great law in it, can have great arguments in it that you can then go and use in yours. Even though it's not a binding precedent, it still has a lot of value to help you build your case.
And I've absolutely done the same thing. I had a case where it was a petition for new and further disability that I took to trial, and it was Judge Banks before she was the PJ, actually, out in San Bernardino. She issued the finding. It was, thank goodness, in my favor, and I read every single word in that decision, and I've used it in other petitions answering, or not petitions, but an answer to a petition for new and further. Some of the law that she cited, some of the reasoning that she used, I've used it. So they're definitely something that you don't want to read, say, oh great, or oh no, this is bad, I have to tell the client it didn't go our way, and then never look at them again. It's definitely something that you want to keep on file. Just in terms of whether it's binding legal precedent, just remember that it's not.
And so you get your opinion, and now you got to decide, do I like it or do I not like it? If I like it, I'm going to hope that the other side doesn't appeal it. If I don't like it, I got to decide, do I want to appeal it? Because every time you appeal, you could potentially be creating law. You don't know how it's going to turn out. It could turn into a published opinion. It could be something that the WCAB rules against you on, and it impacts a lot of cases. And you don't want to be that guy that creates that bad law that hurts your clients. So what you got to do is do the proper analysis. Is there something there to appeal? And if there is, you can appeal it, file, usually it's a recon, and then what'll happen is it'll go to the commissioners up in San Francisco. Basically, the first level is the judge, the work comp judge that we're before all the time. They work on behalf of these commissioners. So you got the 7 commissioners, and then you got all the courts that we go to underneath. And so usually they'll pick out three judges, and those 3 judges are going to then hear this case. There are 7 commissioners total usually. That recently in the last few years there was a vacancy, but 3 will get assigned typically, and then they'll make a decision on a petition for reconsideration or removal.
Now, in order to decide whether or not you want to file a petition for reconsideration or a petition for removal, you are going to look at what type of order was issued. Is this a final order? Is it a non-final order? Sometimes it's a little bit more difficult to decide which is applicable, but as a general rule, if you're looking at a threshold issue, which is something that determines, let's say, causation, compensability, whether there's an employment relationship there, or let's say maybe an independent contractor, whether the statute of limitations applies to bar the case entirely, whether medical treatment is reasonable and necessary or not. Those are the types of things that would be considered a final order, because it makes a substantive decision regarding a right or liability. That's something that you would be filing a petition for reconsideration of, which is, again, just a fancy way of saying you're appealing a final order. Petitioning for removal, you are trying to appeal a non-final or interim order. These are things that could be a hearing being taken off calendar. It could be a hearing, perhaps a status conference being converted to a mandatory settlement conference against your wishes, despite you objecting to that. It could be closing discovery at a priority conference, which we've looked into quite a bit recently, and that's inappropriate for the most part, discretionary. But if there's any reason at all to think that discovery should be left open and the judge decides to close it, you would want to file a petition for removal some of the time. Now, one thing to consider when you're deciding whether or not to file one of these petitions for reconsideration or removal is what happens next. What happens if you do file one of these petitions? And I'm sure some of you may have experience with this. What happens is it sits up at the WCAB for a long time. Right now, I think the last couple of ones I've done in the past have sat up there for 1.5 years, 2 years.
I've got one that's over 3 years, and we keep asking for an opinion. We've gone to the PJ to see if he could help us. There's that new in banc where they essentially said you're not allowed to just grant reconsideration for further review. We use that. We still don't have a decision. I mean, we've followed up like 6 or 7 times, all the parties. It's over 3 years we've tied this case.
I was talking about this with Judge Petty. I had a trial with her just a couple weeks ago, and she was telling me the exact same thing. All of hers that she's involved with, because the judges, have the opportunity to give their opinion and recommendations as to whether or not the petition should be granted. She said she has some that have been up there for 4 years, and despite this new en banc that James was talking about, which, not to get too in the weeds on it, but it requires the WCAB, instead of just issuing a response saying, we're going to take this under review, basically, we need to do some more research. And then they, as far as we can tell, don't do a whole lot for years, and it sits up there. They can't issue those boilerplate decisions. However, they're still doing it, supposedly. That's what the judge was telling me, that every single one she's been getting is the exact same boilerplate language, despite the long decision. So you have to be careful. You have to make sure that it makes sense to do it, and consider the costs of not only waiting so long, but in the interim, while you are waiting for that decision, you're not able to set any other issues for trial. So yeah, no deal.
The case that you were just talking about, to fill into people a little bit, is we were at a priority conference, and there was a little bit of discovery to do. It's a huge case. there was still a little bit of discovery to do. And the judge said, no, we're setting this thing for trial, but there was no order actually closing discovery. And so they were trying to exclude our discovery that we had completed up until the day of trial. And so we ended up having to do a petition for removal, which then tied up the case. We then ended up getting what we needed, and the evidence the judge was apparently siding with us, so we had to withdraw the removal, and that freed up the case. But otherwise, on just whether discovery closed for, talking about a 2-month period, this thing could have been tied up for years on just that issue. And so I was like, let's withdraw it. We got what we need. Let's move on. But it can be a nightmare. So you got to definitely be smart about it. But if you got a losing case and there's a valid ground to appeal, well, then obviously you need to do it. However long it takes. Because if you think you're right, you think you're right.
Absolutely. And if for any reason you're unsure whether or not this order that you want to appeal is final or non-final, what you can do is you can label the petition as a petition for reconsideration and or removal, and then address.
We should do standard. It's standard practice
all
to do
the time. Well, every time we file one of these, we do it. These are something that I think for the most part, you're not going to be filing a lot of petitions for recon or removal. But if you label it both ways and address the grounds for each separately, but in the same petition, then you make sure that, oh shoot, I should have filed for removal, but I filed for reconsideration. Now the timeline to file for removal is gone. What happened? You're covered in terms of the statute of limitations, if you want to call it that, the time frame to file these.
All right, so you decide I'm going to file the recon, and now it's going to get assigned. As I said earlier, it'll go to those three, the three commissioners, and they'll get to decide your case. And the thing is they can, the WCAB at the appeals level, they can do pretty much whatever they want. They really are the ones that have all the authority. They can affirm, they can rescind, alter, they can give wholly new decisions. They're the ones that as I said earlier, the judges at the district offices level they're doing the work on behalf of these commissioners. So the commissioners are like the boss, the way I would look at it, and so they can pretty much do whatever they want it. They're admissible and citable, but they are not binding. So here you got it. This what you think is you get a bad decision. Is it binding? Not necessarily. You can still make arguments for your position, even though there are bad WCAB panel decisions out there. But again, for the same reasons on work comp judge decisions, they still could have a lot of good value, and they're also usually not known to the public. Very similar, but they're very low level decisions typically.
The next level, it would be what is called a significant panel decision, which some of you may have heard that term before, some of you may not have. What this means is that panel decision was decided not just by 3 commissioners, all of the commissioners reviewed it and decided as a whole that the issue that is involved in the decision is an important or significant issue and or one that's recurring.
So these must be binding then, right?
Yes. No, I'm just kidding. No, they're not binding. We'll get there. I promise you, we'll get to those binding decisions, but they are more persuasive than regular panel decisions. And how often do these come about, you might ask or wonder? Well, I wondered that myself earlier today, so I looked into it, and there's been 9 significant panel decisions. What do you think, in the last 6 months? Year? No, in the last decade. In the last decade, there have been
I can't believe that
panel decisions labeled as significant. And the last one was in 2021, January 2021. So that tells you almost 3 years ago now, because believe it or not, we're almost done with 2023. And that was related to the remote hearings due to the COVID-19 pandemic. So it's a label that is attached to very few panel decisions. So when you see that, take a look at it, because it is something that more WCJs are going to pay attention to because it's been deemed significant.
Yeah, and all 7 commissioners review it. They're not. It doesn't necessarily mean that they've all looked at all of the merits. They just agree that that issue is important, it's significant, and so they give it the label.
And that's partly so that instead of having to try to wade through all of these other panel decisions, you can do what I did and go onto the DIR website and look at these ones that have been labeled as important, so that the whole workers' comp community can look at them easily, have access to them, and understand, hey, this was deemed important. It's probably about an issue I'm going to see or already have seen plenty often. Let's take a look at these and pay attention.
But again, if you've got a good argument against that decision, you're not bound by it. You can create different law than that. So the next kind of decision is an en banc decision, and this is the first one, first type of decision that we've talked about that's actually binding. It's where all 7 commissioners, assuming there are 7 at the time, they sit to decide a case, and they achieve uniformity when there are cases presenting novel issues, important issues, and so they will issue that opinion, and and all WCJs are bound by it. All future panels are bound by it, but who's not bound by it is the California Appellate Court. The California Appellate Court can overrule even an en banc decision. However, they're not usually going to do that. It's only in very, very extreme cases where they will do it, because they typically don't want to substitute their judgment in place of the judgment of the commissioners who actually deal with workers' compensation for a living 100%. So that's why there will be great deference to the WCAB, and rightly so.
So what happens if you file a petition for reconsideration and the commissioners take a look at it and they say, you know what, we disagree with you. That decision that you were appealing of the WCJ, we agree with them, and sorry, your arguments are not good enough. What happens then? Anybody? No? Well, you have the ability to appeal to those appellate courts that we just talked about. You would be filing a petition for writ of review. And this is something that you can only appeal final decisions and orders of the WCAB. This is not where you're looking at a petition for removal that gets rejected. This is the final order that you filed a petition for reconsideration and it didn't go your way. You can also file a petition for writ of mandate if it's a non-final order that's involved. Now, these filings of writs are things that don't happen very often. I think, how many would you say you've probably been involved with, James?
I've been involved with a number of them in the civil arena, but in comp, maybe 5.
That's what I was gonna say. Yeah, I think
not very many.
1, maybe 2 ever. Yeah. I think it was maybe just 1. I have some kind of
they don't. The problem with the work comp is really your appeals are in the WCAB level, because in a civil case, when you do an appeal, they have to issue a decision. They can't just summarily deny. They have to give you oral argument. They have to do it's a real appeal. That's your appeal right. In workers' comp, all they got to do is decline it. You don't have an automatic right of appeal in the appeals court. It has to be something that they feel is interesting enough, important enough, to where they're going to accept it, and then by accepting it, they'll render a decision on that issue. So typically, writs what'll happen with your writ, and this is why it's so infrequent that we recommend them, is they typically just get denied without even an opinion, just writ denied. And they don't have to give an opinion, and that's what's a bummer about it. And they can get costly too. They're not cheap to prepare a writ. They take a high skill level, a lot of research, a lot of work. I mean, you can be looking at things like in the legislative intent of codes and having to just really piece it all together, looking at if there's district splits where one court in one district rules one way and another district the other way. You have to analyze all that, and so it can be a tough issue. In I can remember one where I did a writ a number of years ago and actually ended up losing it. It was a case where I had all kinds of fantastic case law on my side. However, none of it pertained with this specific code section that ultimately made, in the court's eyes, made it different, and it essentially distinguished it from every other case. And so ultimately the court ruled against me because of this specific code section, the way the argument was framed by this attorney who did a fantastic job. And so they ended up prevailing on it. And so it's really hard to get a writ. There was a writ that I did there was a case I had. It was in the state court. We kicked it to the federal court. It was a civil case. Kicked it to the federal court. Did all of our discovery. We were about to have a motion for summary judgment heard, and we got kicked out of the federal court back to the state court. And what that did is it opened up all the discovery. They had all our paperwork to know everything we were arguing, and so they could then go and refute it all because they were done. It was the day before the hearing where everything was going to be decided. So we had to do a writ. It was not an appeal on the merits. It was an appeal on whether we should have gotten kicked out of court. So because of that, it was a writ, and the federal court ended up taking it. They set oral argument, and there was a district split. This was actually federal, so there was a district split where some districts found one way and then others the other way. And I was arguing for one specific way. And ultimately, the Ninth Circuit, they set our case for hearing, and they set other cases for hearing on the same exact issue because it impacted thousands of cases. And so ultimately, the court found, I'm not even going to think of going into the technicalities, but the court found in our favor. And then the plaintiff got Stanford Law School and an appellate specialist, and they filed a petition for a writ to the U.S. Supreme Court. And then we obviously opposed it, and the Supreme Court ended up they ended up denying cert. And so the Ninth Circuit, who had issued an opinion in our case, they published the opinion, and it actually became the law in the Ninth Circuit. And so it's been cited thousand plus times, and it's the case on that particular issue. And it all started with a writ. It started with a writ that they could have just simply declined hearing, and instead it went in our way. And sure enough, the summary judgment was granted, and a multi-million-dollar case was gone.
And in that type of a case, it's definitely, I mean, obviously, the outcome was worth it. In workers' comp cases, again, we deal with a lot of cases that aren't multi-million-dollar cases. Sometimes they are. Occasionally, you have those catastrophic losses that end up being very expensive to defend and end up having a huge payout even after you do a whole bunch of discovery and defense work. So if you're talking about a case that soaking wet is worth $25,000, do you really want to incur the costs of paying your attorney to do all this research and file the writ and all of that? Maybe not. But
heck no, unless you're trying to create some law and you got the perfect facts.
Right.
But business decisions always have to be made. All right, so as we mentioned, you file your writ to the Court of Appeals, gets assigned to 3 justices in the district. They will then look at it. Now, the thing with a writ is, let's say it's a credibility issue. They're not going to decide credibility issues. They're going to defer to the lower courts. You're going to have a real good issue. Otherwise, they're just simply going to, they're going to deny it. But if they grant it, they'll say, here, we're going to schedule oral arguments, and then we're going to hear it, and then we'll issue our decision, and it'll be like the case I just mentioned. Now, this is just so y'all know, these are the 6 districts of the California appellate courts. So depending on where your case is, that's where you file your appeal, but that's what it looks like. Those are all 6 right there.
And as we kind of talked about this a little bit, what can happen when you do file that writ is the appellate court can decide I'm going to deny this writ, meaning I don't want to hear it, I'm not going to look at it, it's denied. Now, does that mean that the appellate court agrees with every single thing that's in that decision? No. It just means that they're not going to look at it and make any kind of a judgment as to the validity of that decision. These are not controlling, not necessarily, but they do carry a lot of weight and they are citable. And if you have one that's on point with your case, you definitely want to cite that. There are unpublished opinions that are decisions that are not certified for publication. They have no binding effect, but they are citable so long as the person citing it, which is usually going to be an attorney, makes note that it's unpublished. And
I typically don't touch them. I don't want to be the attorney that's citing unpublished cases. Got to be very careful with that. But those unpublished opinions, I've gotten some really good arguments from them. I've gotten good cases, good analysis. So they actually do have a lot of value, but I don't cite them.
And what you can cite, and you should cite, are the certified opinions. Now these are citable and binding. So you've got the full green light to move forward with those if you have something that's got a favorable opinion to you.
And these even trump, the labor code. They can trump a lot if it's, as long as it's unconstitutional. All right, and so your final remedy is going to be the Supreme Court of the United States, which doesn't happen very often. I'm sorry, the Supreme Court of California. There is the Supreme Court of the United States as well, but that's usually when there's a federal question or it involves multiple states, and that's how they get their jurisdiction. But typically, it's going to be a California Supreme Court is the highest court of the land for us, and so they'll make the decisions. They want to maintain uniformity throughout the whole state, and if it's accepted, then 7 justices may hear it, or they can direct it to a lower court even to decide it. But ultimately, they will issue the opinion, and it's going to be binding on all of us. Of course, they can also change their own decisions. So they make a decision that's binding, and then they can undo that by making a new decision that changes it. So they do have that kind of power. I personally, I can't think of any cases I've had go to the California Supreme Court other than one where we had a quadriplegic case. So there was a lot of expense. It was a civil and a comp case combined. And we had one on the issue at the trial court level. Then it was appealed. We lost on the appeal. Then it was petitioned to the Supreme Court, and then the Supreme Court ended up reversing it back in our favor to dispose of the case. But I can't think of any other instances where I've been involved. Have you been involved in the California Supreme Court?
No.
Yeah, it's rare. It's super, super rare.
So one case that we have as an example here to kind of show you how all of this comes into play for us. Basically, you have the court that takes a look at the labor code section and decides what it means.
And before you get into that, for people watching, it looks like a 4-year-old did the highlighting on this slide, and I want to make sure people know that it was me that did that. It should not be attributed to Liz.
It definitely is. When you blow it up on the screen, it's definitely not coming across.
What the heck happened?
Clean as it looked before. So I'm glad you're taking the blame for that.
Yeah, that was me.
But anyways, back to the case study. So in Skip versus WCAB Guzman, they took a look at Labor Code Section 3208.3D, which for those of you who maybe don't have all Labor Code sections memorized, or you don't have our nifty laminated handout of different.
It's on there.
Which I have one right next to me at all times.
It's right very there. Useful.
So if you don't have one, I suggest putting a note in there that you'd like one. I see some people have already done that. Labor Code Section 3208.3D is our lovely 6-month defense to the psychiatric injury that finally was enacted to try to throw out some of these claims where somebody works for a very short period of time, says that they have stress from work and we have to pay a bunch of money to treat it and all of that. So this labor code section, you have to have been employed for at least 6 months, unless, this is the exception and the whole crux of this case, unless the injury was caused by a sudden and extraordinary employment condition. And what I will say is, even though there's a bunch of words right there, it's pretty vague as to what that means. And as we go into this case a little bit more, you can see that's why this was taken up on the appellate level.
The argument that I get all the time on that is the injury is so severe, so of course it's extraordinary. And I mean, it amazes me so often that and these are, you know, sometimes very good attorneys, and they make this argument. So for example, a guy had his hand almost completely amputated, and so they were arguing that it was sudden and extraordinary, and just because of the injury. But the thing is he was using a saw. It was foreseeable that you could get injured using a saw. And so ultimately, you know, I would say, look, it doesn't matter whether the injury is extraordinary. What matters is whether the mechanism is extraordinary. And so this Skip versus WCAB Guzman addresses that exact issue. So in this particular case, you had this guy using a 95-pound compactor on a hillside, and it was at a 45-degree slope, which is pretty steep. It struck a rock, and ultimately it ended up landing on top of him. And so he had injuries, and he was alleging his various injuries, including a compensable psychiatric injury. And they claimed that they could get around the 6-month rule because it was sudden and extraordinary. And obviously it was sudden, but was it extraordinary? And the answer is, in my opinion, no. And let's see what the court agreed, Lizzie.
Well, let's see. The decision was that he didn't provide enough evidence to show that it was uncommon, unusual, and totally unexpected for the rock to be in the soil, because of course, I mean, if you've ever done any sort of gardening, you know that there's rocks in the soil all the time. And that it would also not be unexpected or very uncommon that if you're using a tool such as a compactor, that it might strike a rock and then fly up or make the operator unbalanced so that they fall. So they decided this was not a compensable psychiatric injury, and it was appealed. And then the 6th District Court of Appeal annulled the decision. And what does that mean? It means they went back, remanded it to the trial court, and said, hey, look, he wasn't employed for at least 6 months for this, so it's not compensable. And originally it was unpublished. So what do we know that means? James?
Not binding.
Not binding. And then shortly thereafter, in this case, only 24 days later, there was an order granting publication of this decision, which is part of why we're talking about it now. So that's a good one.
It's a great one. It also shows you the job of the courts. Here we had this code section, and it needs to be interpreted, and that's what the courts are supposed to do. They're supposed to interpret. They don't write the laws, they interpret them and enforce them. And so this case is exactly the type of example that shows what we've been talking about this whole session. So now what we're going to do, we're done with talking about the various authorities. So as you heard, a lot of them are not binding. Most of them are not binding. And anytime, even if it is binding, maybe you have an argument that you can distinguish your case, so you're still not dead in the water. But you definitely got to know what you're dealing with. It's part of the first thing you look at is who issued the opinion, so you know how persuasive it is and what the value is. So next we're going to go to the types of hearings, and this is really not it's changing gears for sure, but it's very important for you to understand the types of hearings there are, and these are the most common. You got the expedited hearings, priority conferences, mandatory settlement conferences, which everyone calls MSC, and then status conferences. The Expedited hearings, they are usually issues of medical treatment, MPN, TTD issues. Priority conferences are AOE, COE. With expedited, what's different between those and the rest is you go straight to trial. You don't have a hearing in between. You got to be ready. And so I had a case where it was an AOE, COE issue, and the attorney put AOE, COE an issue on an expedited hearing by saying that it was a dispute between two employers or two carriers. Let me strike that. It was two carriers, and we were both arguing the other one had liability, but at the same time there was an AOE, COE issue, and that was the main thing. And so you couldn't decide AOE, COE at an expedited, and so we had to go to a few conferences, and finally the judge agreed that it is not proper to go to an expedited hearing because they have a right to do discovery. They have a right to figure out what they're going to do and not be forced to an AOE, COE trial. And it's only been 3 months since the date of injury, especially on a monster case. So expedited hearings are just that. They're trials on these very limited issues. Priority conferences, you just go from priority conference to priority conference. If you're still doing discovery, the judge just wants to make sure the case is moving along. Discovery doesn't actually close at the priority conference unless, of course, the judge issues an order closing discovery. I have had that. There's one judge in particular who always closes discovery at priority conferences, it seems, except for rare situations. So you got to be ready to go with that particular judge. But outside of him, I've only seen it one other time. So it's very rare. And then mandatory settlement conferences. These are the conferences where you show up, and at the day of that conference, you're done with discovery. It's closed. And if you want to get anything new in, good luck. It's going to be very hard. And so you always want to make sure all your ducks are lined up. Make sure you get, if you're not ready for trial, make sure you get a timely objection to the DOR for the MSC, so that way you can protect yourself and have the argument that discovery shouldn't be closed. And then lastly, you've got status conferences, which can be requested on various issues, but when you show up, you don't have to worry about discovery being closed. You don't have to worry about typically about orders being issued, things like that. You deal with whatever it is that you're there to deal with, and hopefully it allows you to resolve your issue informally.
And the one thing, I think I mentioned this briefly earlier on today, is that if the parties, meaning both sides, do agree to convert that status conference into a mandatory settlement conference, the judge is allowed to do that. But both parties have to agree. So if you're not ready for it to be a mandatory settlement conference, all you have to do is say, I don't agree. But it is something that if it's a minor issue that you were hoping maybe you'd talk to the judge and you'd be able to, via the judge, convince opposing counsel that, hey, I'm right, we need to do this, but that doesn't happen, you can try to avoid that extra time between the status conference to a mandatory settlement conference to a trial date to just convert that to an MSC and set it for trial at that point. That can save you sometimes a month or two. So I've done it before, I think only one time, but it is an option. So what does a DOR, Declaration of Readiness to Proceed, look like? Some of you have probably seen them. Some of you may just kind of skim through them when they come in the mail, but this is what the form looks like. This first one is the just standard DOR, which you can see down here. You can request 5 different types of hearings. They still have the rating MSC on there, even though technically rating MSCs don't exist any longer, but they still get set sometimes, even though
I think my last rating MSC was about 15 years ago.
Yeah, they're not supposed to be requested. I've had a couple recently where they were requested by somebody who had been practicing quite some time and maybe forgot that they're no longer a thing, but they will sometimes still get set. They're effectively, at this point, it would be treated as a mandatory settlement conference, but that's where you can choose which one you'll be filing for. There are lien conferences. When the case in chief is pending, you're not going to see those typically. or you shouldn't see them unless somebody makes a mistake when they receive a DOR at the board. And you'll want to, again, carefully choose which one you want to check off. And the biggest, most important thing about the DOR is that first highlighted sentence on the next page that talks about how you have to list your specific good faith efforts made to resolve the issue before you file the DOR.
Which you're going to sign under penalty of perjury, by the way.
Right. And the judges in the past, I'd say definitely in the past year, have been harping on this more. It used to be you'd see DORs all the time, and sometimes you still do see them that says, you know, we need a hearing on X issue, but there's no listing of dates. There's nothing like that on the DOR, which automatically, procedurally renders it basically ineffective. It's an invalid DOR because you're required to list those efforts. Now, this can be sent email to opposing counsel on X date, sent letter on X date. I typically want to have 2 or 3 efforts that I can list that aren't, you know, day 1, day 2, day 3, but every week or so to show that I've made a good faith effort. They're ignoring me, and I file a pay attention to me DOR. Sometimes it's
you also have to declare that you're done with discovery on that issue too. So sometimes we get people requesting DORs, but we've got depositions scheduled. We've got things scheduled on this. So if we file this DOR for an MSC on the issue ahead of time, we're not really ready, and it's inconsistent with what we said under penalty of perjury.
And that's so, that highlighted portion there. You have to say that you've completed discovery. Yeah.
And then the other tip on this, because we're running out of time, the other tip on this is to make sure that the issues, the compensation rate, PD, AOE, COE, make sure you check the issues you want. If you leave something off you want, you may not be able to go to trial on it. And if you include things you didn't want, then you may be going to trial on something you didn't want. So you got to make sure that the correct issues are actually checked off on the box. All right, let's go to the next.
Yeah, discovery is one. You definitely don't want to check that off. If you're saying discovery is closed and you're done with it, don't check that box.
So this next one, this is what when you need an expedited hearing or someone files an expedited hearing, this is what that one looks at like. It's very similar. The one thing I did want to make note of is if you see the first one says entitlement to compensation is in dispute because of a disagreement between employers and or carriers. In my case that I had mentioned earlier, that's the box that was checked that got me to trial, even though AOE COE was an issue and it was denied.
This last part is just the pretrial conference statement. If you've never seen it, this is what we fill out in order to set something for trial. Typically it would be, especially now, you need to have it filled out and e-filed and signed by both parties before your MSC or expedited hearing. If you're planning on going forward, this is where you'll list the parties who appear, the issues page, or I guess this is is this the stipulation page?
The steps, yeah, that's steps.
My camera is covering up the top
Yeah,
right here.
For the steps, we'll just say it's very important that you don't include stipulations to incorrect information or things that are in dispute or that you're not sure of. So for example, sometimes AAs will try and get it. They'll try and get a stipulation that there was injury sustained. When, boy, mark that off if you got a denied body part or denied claim or whatever. Make them list whatever they're claiming. I'm very careful with steps. I don't like stipping unless it's definitely not something to be concerned with. Otherwise, it should go into the issues. Go to the issues now.
Oh, there we go. Yeah,
this is what the issues page looks like that we have to fill out. We only put the issues that we want in. Both sides have their opportunity to mark whatever they're going to mark, and if they're chicken issues that were not on the DOR, then you can do it. I always make sure my objections are on this document, always on the document. And then at the bottom, it's where it says other issues. That is actually got a bunch of lines where the parties write all kinds of things. And it's so the sheet's actually a little bit longer than that, but this is the issues page. All right, let's go to the next page.
This is where you'll see the judge can put some notes from the trial setting conference, and you're going to want to check that highlighted area, other dispositions and orders. Sometimes on this, the judge, because you can't see them writing in on this when you're not there in person, which most of the time we're not there in person now, this is where they might put something like, the parties are suggested to file a trial brief ahead of time or something like that. I just recently
or discovery is closed.
Or discovery is closed, and maybe you need to cancel.
I may need to appeal that.
Right. So that's
or maybe it's not in there, and I'm saying, hey, Your Honor, I want discovery closed. Will you close discovery?
Right. So take a look at that. Make sure you're paying attention to it. And then that last page is where you're going to list your witnesses and exhibits. And there will be 2 pages, one for you, one for opposing counsel. If opposing counsel lists something you don't have, or you have an objection to it, make sure you put that on the page there, right in the objection to it, because that way nobody can say you didn't raise the objection timely.
Yeah, and I list anything I could possibly want to use because things change. I make sure I list the witnesses because when I'm preparing for the trial in the end, sometimes things I didn't plan to use, I'm using.
Exactly.
And I think that does it, right?
I think that does.
Let's see what the next slide is.
That's it.
It's it. Thank you, everybody.
We appreciate you coming in and listening to us.
Well, I would like first to give everybody an opportunity that would like to have the handout. They've been saying they'd like to have it, to please type in your address into the comments so that we have that and I can forward that on. My apologies. I've gotten sick here, but I'm not going to let that ruin my Christmas. So please make sure that you put your address in so they have an address where they can ship that to. James and Elizabeth, I love your style. It's great, you know, the talk back and forth. And, you know, James, I was looking at the MacroPro YouTube channel, and you have one on identifying and managing high exposure claims. And it has a lot of people who've gone in and watched that after the fact. So, you know, if you ever want to watch James again and Elizabeth, they are on the MacroPro YouTube channel.
The internet is forever.
Yeah, unfortunately. Well, thank you very much, everybody. It's a pleasure to have been here. Thank you, Diane, for having us. And Lizzie, you know what I think of you. You're the best.
So a couple other things I'd like to mention. It is taking a while for some of the firewalls to let the certificates come through. So make sure that you give it at least 2 days before you start worrying about your certificate. Next, the acute rehab webinar has been hijacked twice by the Grinch. We have stolen it back and we have rescheduled it for Friday, December 22nd at 11:30. So if you were already scheduled for that, you are automatically rescheduled for that. If not, you can certainly go on to macropro.com and sign up for that. So this is the 5th, what should have been the 6th webinar. It is the 5th, so we still have 7 more webinars for you to watch. And we've got some really great ones. So make sure that you check the MacroPro website and make sure that you are signed up for all the ones that you would like. Acute rehab is coming up. Legal counsel involvement is going to be the next one, and affirmative defenses, which is actually something that James loves. He loves affirmative act.
I love it.
So do I.
So excellent. All right, everybody. Well, thank you so much for joining us. I'm sorry about my frogginess and my foggy brain, but I'm so happy to be here with all of you. We'll talk to you later. Bye-bye now.
Bye.
Holidays.
Happy holidays.